Your Honour, with leave, Mr. Donnelly for the plaintiff. Thank you, Your Honour. This is an application, Your Honour, by way of notice of motion seeking two orders. Firstly, that there be an adjournment of the hearing date, and secondly, that the plaintiff be given leave to amend its statement of claim. If I may, Your Honour, I shall begin by addressing the application to amend the plaintiff's statement of claim first, as the application to vacate the hearing date will be informed by that. Your Honour, the plaintiff seeks the Court's leave under Section 64 of the Civil Procedure Act to amend their statement of claim to include a new cause of action under Section 18 of the Australian Consumer Law. The plaintiff alleges the defendant engaged in misleading or deceptive conduct, Your Honour. By way of explanation, following production of the broker's file under discovery, it became apparent that Miss Karen Clarker of the defendant company had a relevant conversation with Mr. Peter Smeld, a former office manager of the plaintiff company. The conversation took place on 1st of November 2019. Mr. Smeld was seeking the invoice for the insurance premium paid by the plaintiff to the defendant. The file note indicates that Mr. Smeld specifically asked for separate invoices for plant and machinery insurance and for business interruption insurance. Indeed, the plaintiff's head office required this for taxation purposes, Your Honour. The file note discovered helps improving the plaintiff's case, and Mr. Smeld is a critical witness for the plaintiff in proving that the plaintiff did indeed specifically ask the defendant for business interruption insurance cover to be put in place. Your Honour, Mr. Smeld has subsequently left employment of the plaintiff and taken a position with another business. We're working to locate him in anticipation of obtaining a statement. Your Honour, after reviewing the discovered documents and the plaintiff's evidence, it has become clear that it is strongly in the interests of justice that the plaintiff's statement of claim be amended to include a plea of a breach of Section 18 of the Australian Consumer Law by the defendant. Amending the statement of claim is crucial to allowing the real issues in dispute to be determined, Your Honour, and to avoid multiple proceedings. As mentioned previously, Your Honour, this application is in accordance with the legislation concerning the amendment of documents in civil procedures. As Your Honour will know, the Civil Procedure Act at Section 64, Amendment of Documents generally, provides that at any stage of proceedings, a court may order that any document in proceedings be amended, or that leave be granted to a party to amend any document in the proceedings. Rule 19.1 of the Uniform Civil Procedure Rules also allows the court to order a statement of claim to be amended after a hearing date is fixed. Of course, Your Honour will be aware that a decision to grant leave or an order to amend the statement of claim must be made with the overriding purpose in Section 58 of the Civil Procedure Act in mind. It is our submission that the granting of leave to amend the statement of claim is in keeping with the requirements of Section 58, as it will facilitate the just, quick and cheap resolution of the real issues in the proceedings. In this case, Your Honour, a real issue, that is that the defendant had engaged in misleading and deceptive conduct, became apparent because of discovery. And without amending the statement of claim, that real issue will not be resolved. That would not be in the interests of justice, Your Honour. Subsection 2 of Section 64 says, subject to Section 58, all necessary amendments are to be made for the purpose of determining the real questions raised by the proceedings. It's also submitted that Section 64.2 supports the application and that an amendment should be made in this case. Discovery is a normal part of proceedings, and although it is regrettable that some delay and inconvenience may result from the granting of leave to amend the statement of claim, this must, as Judge Shaw said in this court in Wenton Northwood 2003, must be balanced against the prospect of further costs and delay in the event that the plaintiff commenced fresh proceedings. By hearing the fresh cause of action at the same time, we are avoiding a multiplicity of proceedings. It is certainly in the interest of justice to have all matters heard and dealt with at the same time. And as stated in Cropper and Smith, 1884, generally, a party should be entitled to an amendment to permit the real issues in dispute between the parties to be finally resolved. No doubt that is tempered somewhat by Section 58. Your Honour would no doubt realise there's a risk that the plaintiff may be stopped from raising a subsequent cause of action if we do not litigate now, based on the authorities of Port Melbourne and Anshan and Henderson and Henderson. I respectfully submit, Your Honour, that it would not be in the interest of justice to put the plaintiff in such a position. Additionally, Your Honour, as found in LAW217 and Public Transport Commission of New South Wales 1976, Where an amendment is to give effect to evidence before the court that will, if accepted, establish a different cause of action, the pleading should be amended to reflect this. There is evidence from discovery, Your Honour, that may be so categorised. You will hear, Your Honour, from my learned friend that this application is opposed and that the granting of leave to amend the statement of claim will prejudice the defendant by introducing additional costs and inconvenience in response to a new case to answer, and that therefore the application should be denied. In answer to that claim, Your Honour, we submit that the same facts and evidence will be relied on with the addition of confirmatory statement from Mr. Smeld. Indeed, Your Honour, the basis of amendment was always within the knowledge of the defendant, as the evidence comes from their own documents. It is our submission that the granting of an order for costs will adequately compensate the defendant for the additional time and inconvenience caused, and that case management and timetabling will ensure the defendant is provided with adequate time to assess the real question in the amended claim and to respond accordingly. Indeed, Your Honour, it may even save time for the defendant should they change their mind about their prospects in defending this matter in the face of the new statement of claim. My learned friend will likely point, Your Honour, to the High Court's decision in Aon Risk Services Australia Limited and Australian National University 2009 case, Your Honour, where the court concluded that all matters relevant to the exercise of the power to permit amendment should be weighed, including not just the effect on the parties to the case, but also to the larger ecosystem of litigants who may be affected by undue delays in court process. Now, this is undoubtedly true, Your Honour, but the High Court also said in that same case that parties should have sufficient opportunity to identify the issues they seek to agitate. Discovery provided this opportunity to the plaintiff, Your Honour. This application to amend is raised at the earliest opportunity, and it is our submission that when all relevant matters are weighed up, it is entirely reasonable and just for the court to grant leave to the plaintiff to amend the statement of claim. This is not, Your Honour, a situation where the amendment sought is obviously bad in law, or one where it is liable to be struck out if contained in the original pleading as stated in Commonwealth and Verwayen. The claim under Section 18 of the ACL is a valid and good cause of action at law. The limitation period has not expired and it has reasonable prospects, Your Honour. That is to say, it is arguable on a reasonable view of the evidence and the law as stated in the State of Queensland and JL Holdings Proprietary Limited 1997. Excuse me. Nor, Your Honour, is it a case where the trial has started. It is not a matter that has been on foot for a considerable amount of time, distinguishing it in that respect from Aon, as some 17 months had passed when leave to amend the statement of claim was sought in that matter. The prejudice to the defendant in our case is limited by the comparatively early application for leave. The hearing date is still some 6 months away, Your Honour. For the reasons outlined, I respectfully submit that it is in the interest of justice for the leave to be granted to the plaintiff to amend their statement of claim, and I formally request that the court so order. Your Honour, I will now address briefly the plaintiff's request for an adjournment, although it may be a moot point should the previous request be granted, as presumably the hearing date would move to accommodate the defendant's response. Your Honour, the court has an inherent power to regulate its own proceedings as stated in John Fairfax and Sons Proprietary Limited and Police Tribunal of New South Wales 1986. That includes the power to adjourn a matter as described in Sydney City Council and Kersu Investments Proprietary Limited 1985 case. The court also has statutory power and Your Honour has the discretion to grant an adjournment under Section 66 of the Civil Procedure Act. In considering whether to do so, Your Honour must again keep the overriding purpose at Section 58 in mind. Your Honour, since the hearing date was set, new information has come to hand in relation to the availability of an expert witness in this matter, a Professor Atticus Finch of Insurance Brokers Australia. The plaintiff will rely on the evidence of Professor Finch to prove that the defendant was negligent in the provision of advice and insurance coverage. My learned friend also requires Professor Finch for cross-examination. Professor Finch has informed us that the trial date conflicts with another commitment and he will be out of the country on the 20th of November, the date of the trial. Professor Finch is an important witness for the plaintiff, and to proceed without his evidence would be to diminish the plaintiff's case against the defendant. Your Honour, if I could draw your attention to the bench book on this subject, which says at page 602, paragraph 2-0230, that a party or a material witness is unavailable will usually be a sufficient ground for an adjournment, provided such unavailability is not the fault of the party whose interests will be prejudiced by the refusal of the adjournment or of his or her solicitor. That's from Walker and Walker, Your Honour. Your Honour, this information has only recently come to light and was not known by the plaintiff or his solicitors at the time the date was set. We accept that it would be proper for an order for cost to be made to compensate the defendant for expenses and inconvenience, and I respectfully submit that this application, when considered in combination with the request to amend the plaintiff's statement of claim, tips the balance of justice well and truly in favour of the plaintiff, and I ask the court to use its discretion in granting this application for adjournment with orders as Your Honour deems appropriate. Thank you, Your Honour.